Yes, my lord. Humbly for the appellant, my lord.
Yes. There's any other appearance? Chuka Osolu. Chuka Osolu Ojukwu.
Chikoso Ojukwu for the first and second respondent. We're very grateful.
What about Segun Fiki?
My Lord, he just is not fully wrote, but he appears with me, Shegu Fiki, Esquire. We thank the court. The court has disappeared.
Okay, I'm so sorry. We're having a little bit of technical challenges. My lord will soon be back on. And please, you can sit down to announce your appearance so we can see your face. If you stand up, you're blocking the camera. Thank you very much.
Atoleba has left too.
Chika Osolu Ojukwu. Can you hear me?
I hear you now. You just unmuted yourself.
Okay. Sorry for the technical hitch. Atolagbe, can you hear me?
I can hear you, my lord.
All right. So we go on with the judgment. The judgment was prepared by me. This appeal stems out of the decision of the Federal High Court, Abuja Judicial Division, delivered by Honorable Justice A.R. Mohammed on 10 September 2020 in suit FHA-CABJ-CS 94620. The respondent had by an originating motion or notice filed on 11th of August 2020 claim against the appellant as follows. I laid out the relief sought, the grounds upon which the reliefs were based. So upon argument on the origination motion, the learned trial judge gave considered judgment and found in favor of the respondent, first and second respondent on reliefs 1 to 6. The appellant was dissatisfied and had now filed notice of appeal containing 5 grounds to this court. The appellant filed brief of argument on 18 December 2020. It was dated the same day. The first and second respondent brief of argument was dated and filed 13th January 2021. The appellant reply brief was dated and filed 19th January 2021. It must be noted that the third respondent filed no brief of argument. The appellant distilled 2 issues for determination as follows, and that is whether the first and second respondents' application for enforcement of their fundamental rights before the trial court was not incompetent, having been jointly filed, see grounds 2, notice of appeal, and whether the trial court, that's issue 2, was right when it granted reliefs 1, 2, 3, 4, 5, and 6 sought by the first and second respondent before the court. That one based on grounds 1, 3, 4, and 5 of the notice and grounds of appeal. The first and second respondents also distilled 2 issues for determination, and that is whether the trial court was wrong to have refused to consider the additional authorities supplied by the appellant after judgment had been reserved, and whether the trial court was right when it granted reliefs 1, 2, 3, 4, 5, and 6 sought by the first and second respondents. Now there was notice of plenary objection filed by the first and second respondent asking this court to strike out issues 1 and 2 of the appellant's brief of argument, as well as argument connected thereto insofar as they are distilled from grounds 1 and 2 of the notice of appeal dated and filed on 17th November 2020. 2, another of this court striking out the appeal, same being hypothetical and incompetence. There was argument for and against the notice of plenary objection. Now on the notice of plenary objection, I said, now an incompetent notice of appeal cannot confer appellate jurisdiction on this court, and where an issue or issues for determination are not derived from the competent grounds of appeal, the said issues and grounds of appeal will be struck out. It must also be pointed out that an appeal must be a direct challenge to the nucleus or ratio decidendi of a judgment. See Okwara Agu against Julius Baja, 2019, 11 NWLR Pass 1682, 165 at 182, Galumje JSC. I quoted my lord. I also refer to the case of Francis against FRN. Citation supply is 2021, 5 NWLR, part 1769, 398 at 413. And I said, I've already reproduced the grounds of appeal as contained in the notice of appeal of the appellant, and I am of the firm view that the said ground 2 complains of failure of learned trial judge to consider the effect of the decision of this court forwarded to the trial court, which is to the effect that the suit of the respondent was not properly constituted, in that two persons cannot jointly file an action bordering on enforcement of fundamental rights. Therefore, issues 1 and grounds 2 of the notice of appeal from which it was distilled are competent. They have to do with the competence of respondent's suit and the jurisdiction of the lower court to entertain the said suit. Ground 1 of the notice of appeal filed by the appellant contends that the lower court was in error in granting release 1, 2, 3, 4, 5, and 6 in respondent's favor, because according to the appellant, order of court and valid search warrants were obtained before the account of first respondent was frozen and documents along with other properties were taken into appellant's possession. It is thus a valid ground of appeal, and the issue distilled from ground 1 along with grounds 2, 3, 4, 5, and 6 are valid in law. Consequently, the first and second respondent motion on notice dated and filed 13th day of January 2020, seeking to strike out issues 1 and 2 nominated for determination by the appellants, grounds 1 and 2 of the notice of appeal, and others striking out the appellant's appeal for being hypothetical and incompetent, is hereby dismissed as lacking in merit. Now to the merit of the appeal. I hope learned counsel are hearing me. I hope you can hear me. All right. Now to the merit of the
you, my lord.
Yes. Now to the merit of the appeal. All right. The
I can hear my lord.
On the two issues formulated by the appellant. I've laid out the two issues, and arguments have been canvassed by learned counsel to the parties on the two issues. So the findings of the court on all the two issues raised are that it is straight law that a court cannot adjudicate upon a matter that is not initiated in accordance with due process. A court cannot adjudicate on an incompetent action or an action commenced in violation of the law or the Constitution. Any proceeding conducted without jurisdiction will be rendered null and void ab initio. CCBN and Global Resources Limited, citation supplied. Aruese against Nwakoni, citation supplied. Attorney General of Lagos State against Eko Hotels Limited, citation supplied. The squarely tried that where court lacks jurisdiction to entertain a cause or matter, the entire process, no matter how well conducted, is an exercise in futility, and the proceedings, no matter how well conducted, will be liable to be set aside. The lower court agreed with the position of the appellant when it held on page 42 of supplementary record as follows: while the said authorities lend credence to argument of learned counsel to the first respondent, and which authority this court holds in awe, and it is bound by it, the learned trial judge, however, deviated and did not apply the said authorities. The lower court reason for his action can be found on pages 42 to 43 of the said supplementary record, where the learned trial judge said, I quoted his lordship. What his lordship said was that because argument had closed, he has reserved judgment and that it will be an infringement of the fundamental right of the first and second respondent to reopen the matter, that what the appellant ought to have done was to have applied to the court to reopen the matter. I am of the solemn view that the learned trial judge was wrong for taking such a position, in the face of his acknowledgement and acceptance that the case referred to by the appellant, learned counsel, supported the position that the two or more persons cannot enforce their fundamental rights in a single or same action. The fact that the learned trial judge said that the appellant counsel ought to have referred to the cases at the lower court before a reserved judgment is beside the point. I stated earlier, it is an issue bordering on the jurisdiction of the lower court, and there's no time limit for raising an issue of jurisdiction in a matter. It can be raised and entertained at any stage of the proceedings, and once it is raised, it must be promptly attended to and decided one way or the other before delving into the merit of the matter. It is a matter the learned trial judge will raise of his own motion. See the case of Chief Daniel Oloba against Olubodun Akereja, 1988 citation supply, and the case of Kida against Ogumola, 2016 citation supply. What the learned trial judge ought to have done in the circumstance was to have directed the issuance of hearing notices upon the learned counsel to the parties to enable them address him on the implication of the additional authorities forwarded to the court in order to afford the parties opportunity of fair hearing. More so that the learned trial judge believed that the authorities supported the point being canvassed by the learned counsel to the appellant as forwarded. The position of this court, as decided in the aforesaid cases, was again reiterated by this court recently in the case of Chief of Naval Staff, Abuja, and 7 others against Achibong and others, 2020 LPLR 51845 CA, where my Lord M.L. Shaib said, I quoted in extenso, and the long and short of it is that there can be no joint action to enforce fundamental rights. For avoidance of doubt, Section 46(1) and 2 of the Constitution of the Federal Republic of Nigeria, as amended, provided any person who alleges that any of the provision of this chapter is being or likely to be contravened in a state in relation to him may apply to a high court in that state for redress. 2, subject to the provision of this Constitution, a high court shall have original jurisdiction to hear and determine any application made to it in pursuance of the provision of this section, and may make such order, issue such writs, and give such directives as it may consider appropriate for the purpose of enforcing or securing the enforcement within that state of any right to which the person who makes the application may be entitled under this chapter, unquote. In any event, where a matter touches and concerns the jurisdiction of the court, it can so motu be raised and decided by the same court without recourse to the parties. See Adebayo Segun Oni against John Kayode Fayemi, 2020, 15 NWLR, part 1746, 59 and 79, where my Lord Amiru Sanusi, JSC, said, it is, however, my view that where the issue raised or is to be raised touches or strictly relate to issue of jurisdiction, the court can equally raise the issue so motu and determine such issue without necessarily hearing the parties. And his lordship said some other things, which I quoted. I am of the view that since the action was not properly constituted, the lower court has no competence or finesse to have entertained the action as it was incompetent. Another snag in the respondent's suit is that reliefs were sought jointly with an artificial entity, Energy Property Development Limited, and the entire action centered on the freezing of the said company's account listed in Exhibit A, attached to first and second respondents' affidavit in support of the application at the lower court. Reliefs 1, 2, 3, and 4 relate to first respondent account. The rights of action of the first respondent cannot be vindicated via enforcement of fundamental rights. The right of action sound in tortious action or breach of contract by the writ of summons and not in fundamental rights enforcement procedure. The detention of the respondent documents of title by the appellant is more of a right in detinue action and not enforcement of fundamental rights. The first respondent is not entitled to such right under Section 46 of 1999 Constitution as amended. There is nothing to show on record that the directing minds of the first respondent were arrested or detained on account of relief sought by the first respondent, either jointly or alone. See First Bank of Nigeria against Attorney General of the Federation and others, 2018, 7 NWLR Part 1617, 121 at 151, 155, by my Lord Augie, JSC, who said, as it stands, the question that rears its head is whether a bank, the first appellant, can be physically arrested and detained by EFCC. The appellant argued that it can be arrested and detained by proxy. That is, since second to fifth appellants, who are key officers of the bank, were arrested and detained, the bank was also affected. They contend that the implication of the incarceration of its key officers was financial loss and loss of reputation to the bank. This line of argument obviously lacks merit. The first appellant has every right to seek redress for financial loss and loss of reputation occasioned by the arrest and detention of the said key officers, but it cannot do so through procedure provided by law under Fundamental Human Rights Enforcement Procedure 979. The applicable rule in this matter are not the present 2009 rules. So any claim touching on violation of rights to personal liberty guaranteed by the Constitution are usually made before the court under Fundamental Enforcement Rule enacted for enforcement or the protection of fundamental rights. At page 173, my Lord Akas had this to say, I entirely agree that the first appellant, being an artificial person, cannot maintain an action for violation of his fundamental human rights because first appellant is incapable of being arrested or detained. The second to fifth appellant, being natural person, are the ones who can institute an action for the enforcement of their fundamental human rights, unquote. And my Lord Okoro GSC also said, the first appellant not being capable of being arrested and detained is not entitled to damages in the matter at hand. It may have its remedy elsewhere. Issue 1 is resolved in appellant's favor. The settled position of the law is that where it is shown or established that the lower court has no jurisdiction in a matter, the appellate court must still proceed to consider the merits of the matter as admonished by the Supreme Court. See the case of Alhaji Jibril Hassan against Babangida Aliu. I will, however, proceed to determine issue 2 on the merits in this court, if this court should be found to be wrong by the apex court. So I decided to hear the matter, that's issue 2 on the merit. And that one is as to whether the trial court was right in granting reliefs 1, 2, 3, 4, 5, and 6. And I laid out the argument of the parties, and I said that it must be stated that It does not lie in the province of a court to make case for the parties, as the court and the parties are strictly bound by the case put forward or presented to the court. The learned trial judge held that the account of first respondent was frozen between 15/4/2016 and 3/5/2016 without a court order, and no court order was served on the first and second respondent, and that there was no evidence to show that Exhibit RJ1 was served on the respondent, that Exhibit RJ4 was obtained on 25/5/16 after the account of first respondent had been frozen, and that there was no evidence during the hearing of the application that RJ1 and 4 were served on the second respondent at the trial. My finding there was that the learned trial judge himself said that the third respondent did not file any process before the court, and that it was taken that he has no answer to the first and second respondent's application. The learned trial judge also gravely erred when he found at page 40 as follows, that there is no evidence during the hearing of the application that Exhibit RJ1 and RJ4 were served on second respondent. The second respondent to the application at the lower court was and is FCMB, and the learned trial judge has found in the course of his judgment that the Self-First Monument Bank did not respond to the originating motion. On page 33 of supplementary record, the learned trial judge found it is instructive to note that second respondent never responded to the applicant deposition by way of counter affidavit unquote. The lower court cannot make case for any of the parties. There is no such case made by second respondent to the application before the lower court. That is even not the position of the applicant, now first and second respondent. The lower court has thus brought in extraneous matters to influence his decision. It also showed that there was no proper evaluation of the affidavit evidence before the court. The lower court was bound to dispassionately consider all the affidavit evidence before the court to enable it to reach a decision and not engage in speculation. See Simeon S. Echukwu against Onwuka, 2016 citation supplied, and that it is the duty of the lower court to evaluate all affidavit evidence. See Lafia local government against the executive governor of Nasarawa State, citation supplied. I also make the point that paragraph 9 to A to B of the affidavit in support, sworn to by Jesu Damilola, all the cases made there was that there was no order, there was no search warrants and so on. The appellant responded by counter affidavit, and paragraph 7 to 17 narrated the reason for their entering upon the premises of the respondents, and that they obtained order from Justice Nyaku to cover their action. They also obtained search warrants from Lagos State Magistrate Court, and they searched the place, and all the things collected from the premises were itemized in all the search warrants, RJ3 series. And the respondent, the first and second respondent to this appeal, did not reply to most of the paragraphs, especially paragraph 10, 11, 12, 15, 16, and 17 of the counter affidavit to deny the assertion of the appellant. And I held that against the first and second respondent. And I rely on the cases of Obunseli against Uwakwe, Matthew Owuru against Michael Adigu, citation supply, that where there is a very serious allegation contained in counter affidavit, it is the duty of the applicant to controvert the counter affidavit by further evidence and further affidavit. What the first and second respondent did by their further and better affidavit was to contend that the paragraph referred to were argumentative and they were in breach of Section 115 of the Evidence Act. The learned trial judge ruled against them, that they were not against the section, that is against Section 115 of the Evidence Act, meaning that those paragraphs of the counter affidavit remain intact against the respondent. And on that basis, I found that the appeal of the appellant is meritorious, and the appeal is allowed. But having resolved that the court lacked jurisdiction, however, in view of the earlier finding that the lower court lacked jurisdiction on account of the fact that the action was not properly constituted, the applicant's suit FHC/ABJ/CS/946/2020, Energy Property Development Limited and another, against Economic and Financial Crimes Commission, EFCC and another, is hereby struck out for want of jurisdiction on the part of the lower court. There will be no order as to cost, and that is the judgment of the court in the matter.
As the court pleases.
As the court pleases.
Thank you very much. We go to the next one.
As the court pleases.
On the part of the
Hello, we are very grateful for the well-considered judgment.
I want to thank my court for a well-considered decision. We thank you.
Thank you very much.
Thank you for your
So we go to the cross appeal.
As the court pleases.
All the cross appeal.
Yes, ma'am. Judgment appeal number CA/A/CB/9948/2020 between Energy Property Development Limited and another, and Economic and Financial Crimes Commission, EFCC. Parties are absent, my lord.
All right. Yes, appearance.
With profound humility, my lord, our appearance is the same in respect of sister appeal.
All right. Are you appearing with Shegun Fiki?
Yes, my lord.
All right.
Respectfully. Thank you, sir.
Hey, please, my lord.
Yes.
I am O.A. Atolagbe. I appear
Yes.
with my learned friend, H.T. Adebiyi, for the first cross-respondent.
With H.
Thank you, my lord. With H.T. Adebiyi.
For first cross respondent.
First cross-respondent, my lord.
All right. Now, the cross appeal, I will not waste much of our time. The cross appeal 2 is against the decision of the lower court, principally on the admissibility of exhibit RJ series, which was, that's exhibit RJ3, which was held to be admissible by the lower court, and which the lower court found that EFCC, who has custody, is in a position to certify the said exhibit, because the contention of the cross appellant was that it is the magistrate court in Lagos that can certify it, that it is not in the custody of EFCC, and that the lower court was wrong, having found that their right was violated at least for almost a month, that he failed to award damages for the cross appellants. So those are the main grounds in the cross appeal. But my position is that since I have found that the lower court has no jurisdiction in the main case, then this cross appeal to this court will have no jurisdiction to entertain it. But on the same authority, that is another case, that is authority of visa against INEC, the Supreme Court has also admonished us that we should determine the merits of the matter, so that if it goes before the Supreme Court and it is found that this court is wrong on issue of jurisdiction, then instead of sending it back for rehearing or for hearing de novo, the Supreme Court will have opportunity of what we decided and just determine the matter there instead of wasting everybody's time and for putting anybody in extra expenses. So what I said was that, well, I rely on the case of the Supreme Court, where I said that that's the case of ISA against INEC. The Supreme Court, by my lord, wrote 5-4, said that it is safe to say that there are two schools of thought on this. The first is that if the penultimate court, that is the Court of Appeal, find that it has no jurisdiction over an appeal, or that the trial court was right to decline jurisdiction, it should say so and provide to give a decision on the merits. The second is that if the Court of Appeal is of the view that the sole issue, that is jurisdiction, disposes of the appeal, there will be no need for court to consider other issues. There is no sanction known to law for whichever school of thought a penultimate court decide to follow. But following the first school of thought is to be desired, but there are exceptions. In the first place, if the Court of Appeal does not appeal the Supreme Court with a judgment on the merits, it may unwittingly amount to a denial of fair hearing and may occasion a miscarriage of justice. The Supreme Court will have to send the case back to the Court of Appeal for a rehearing on the merits if that court was wrong on jurisdiction, and this will be at great cost and waste of judicial time, unquote. So following from there, I now considered the two issues in the cross appeal, and the two issues whether or not the lower court was right to hold that the first cross respondent is the proper party to certify Exhibit RJ3, and two, whether the lower court was right to have refused to grant relief 8 of the cross appellants for award of 5 billion naira damages against first cross respondent. And I went on issue 1, I laid out the arguments. On issue 2, the arguments were laid out on both sides. And I said that the vehement contention of the cross appellant under issue 1 is that the lower court erred in law in holding that the first cross respondent can certify Exhibit RJ3 contained on page 135 of the record of appeal. The said Exhibit RJ3 is in series and was originally issued by magistrate in the Lagos Magisterial District of Lagos State Judiciary on 26 October 2015 in favor of all law enforcement agents to enter the premises of second cross appellant to search and recover incriminating documents, vehicles, etc. The document is exhibited to counter affidavit of first respondent in opposition to the applicant's application for enforcement of their fundamental right. Like I said, it was referred to in paragraph 12 of the counter affidavit of EFCC against the first and second respondent suit at the lower court. So, like I found in the main suit, since the contention was that that paragraph 12 was offensive and against section 115, the lower court also ruled against the cross appellant. And I said the cross appellant failed to appeal the findings of the lower court. And that means the first and second respondent who are now cross appellants must be taken to be satisfied by the decision. I refer to Trebank PLC and Pharmatech Industrial Project 2019, 12, Part 2, SCM treble 1 at 143, Pakekere GSC, and the case of Wali against APC 2019, also citation supply by ECO JSC, all to the effect that if there is an adverse finding of a court against a party and it fails to appeal against it, it must be taken to have accepted the finding. Without much ado, paragraph 12 of the first respondent counter affidavit is deemed admitted by the cross appellant. The said exhibit RJ3 form part of the said counter affidavit and cannot be objected to, having formed part of the affidavit evidence of first cross respondent before the lower court. The content of exhibit RJ3 are deemed to be part of the evidence before the lower court, and it cannot be objected to at that stage. See the case of Simeon Eseshuku and another against IOC Onwuka by my Lord Peter Odili GSC. And this is what his lordship said. The stance of the appellant is that exhibit R, being a public document and a photocopy, not certified, should be expunged by the court, which will result in the collapse of the respondents from the trial court. That position of the appellant is not for our purpose here, as it is not disputed that only certified true copies of public documents are admissible in evidence in legal proceedings, and any objection to admissibility of copies of public documents not properly certified can be raised during a trial. However, it is also tried that all documents attached to an affidavit, such as Exhibit R, form part of the affidavit in question, and it is not possible to raise objection to its admissibility in the respondent affidavit without running counter against Section 81 of the Evidence Act, unquote. The document SBRJ3 is therefore not liable to be objected to by the cross appellant and is deemed to be part of first cross respondent's counter affidavit. In any event, Section 105 of the Evidence Act provides copies of documents certified in accordance with Section 104 may be produced in proof of content of public document or part of public document of which they purport to be copies, unquote. The parties are adding that Exhibit RJ3 is a public document within the meaning of Section 102 of the Evidence Act, which I reproduce. Thus, upon issuance of Exhibit RJ3 in favor of first cross respondent for execution of the search warrants, they became part of the record of the first cross respondent, that is EFCC. In other words, the said search warrant form part of the record of official acts of the first cross respondent, and as such, the Evidence Act placed it in statutory position under Section 102 thereof to issue out certified true copy of the said exhibit RJ3 through any of his designated or appropriate officers of the first cross respondent in accordance with Section 104 of the Evidence Act, which are also produced. The first cross respondent did not need to go to Lagos State Magistrate Court, where the search warrant was initially issued, before it could certify same from the original search warrant, or even certify true copies in possession and custody of the officials of first cross respondent. The document can properly be certified by first cross respondent, as was done in this case. The lower court was right in its decision that the first respondent is the proper party or person to certify exhibit RJ3. See Enseruke against Edosian 2016 6 NWLR part 1508 citation supplied. Then PDP against INEC, citation supplied. Issue 1 is resolved against cross appellant. Issue 2 has to do with whether the lower court refusal of relief aid seeking for award of 5 billion in damages against first cross respondent was right. I rely on what I said in the main appeal and the case of First Bank of Nigerian PLC against Attorney General of the Federation to hold that the first cross respondent, first cross appellant and second appellant are not entitled to award of damages because all the documents mentioned, none belong to even first respondent. Even if it belonged to the first respondent or the second respondent, the action, like I said, ought to be in detinue. So issue 2 is also resolved against cross appellant, and the cross appeal is thus dismissed.
As the court pleases.
So, but again, because I have found that the court has no jurisdiction, so the appeal, that is the cross appeal, is struck out based on the finding that there was no jurisdiction. So we have both the finding on jurisdiction and on merit in the proper order is to strike out the suits and the appeal emanating therefrom. That is the judgment of the court.
As the court
We are
pleases.
indeed very grateful.
Thank you very much.
Thank you.
So we go to number 3.
As the court pleases.
Call
Judgment number CA/A/20/2020 between Joel N. Onumonu and Alhaji Mohammed Zira and another. Parties are absent, my lord.
appearances. Appearance, learned counsel. Joel Onumonu.
I am Joel N. Onumonu, the
Yes.
appellant appearing in person.
All right. Yes, any other appearance?
Yes, my lord, with profound humility, Dr. Ayodele Gata. My humble appearance is for the respondents. I apologize for their absence, my lord.
All right. So the judgment here was also prepared by me. The appeal is against the judgment of High Court of Justice of the Federal Capital Territory, Abuja, delivered on 4th day of May 2019, dismissing the suit of the appellant. The appellant as plaintiff at the said court commenced this action, filed the writ of summons issued on 31st day of May 2016, wherein he claimed as follows. So the claims are many, almost 13. Pleadings were duly exchanged and matter proceeded to trial, at the end of which Honorable Justice Othman Musa found against the appellant as follows. I quoted what he said. All he said was that the appellant did not establish that Inua Mohammed Sira was agent of the respondents or that they instigated him to report the appellant to the police, and that the appellant failed to prove his case as established by the case law, that is issue of malicious prosecution and all the others, that they were not proved. And so said, I hold that the plaintiff case lack merit and is bound to fail. The case fails and it is dismissed. The appellant was aggrieved and has by his notice of appeal dated and filed 9th August 2019 appeal to this court on 2 grounds, which without their particulars are as follows. The grounds are very prolix, so I just took out ground 1 and ground 2 of the appeal. The appellant amended brief of argument was dated 18th March 2020 and was filed on 23rd day of March 2020, but was deemed properly filed on 2nd November 2020. Respondent brief of argument was dated and filed 25th day of November 2020. The learned counsel to the appellant distilled 2 issues for determination, and which is whether the appellant did establish at the trial that Inua Mohammed Sira acted as agent of the respondents when he laid the complaint of joint act criminal trespass cheating to the police on February 28, 2014 against the appellant and Daniel Adeisa, and whether in view of the evidence adduced at the trial, the judgment ran counter to the evidence before the court, occasioning a perversity and miscarriage of justice. These issues should relate to ground 1 of the notice of appeal. 2, whether the learned trial judge was right in law when it ignored and refused to be guided by the principles of law enunciated by the superior courts in judicial authorities cited and relied upon by the appellant, and thereby failed to apply same to the facts of the case. This issue relates to ground 2 of the notice of appeal. The issues nominated by the respondents are on all fours with what the appellant nominated, and what the respondent couch is whether or not Inua Mohammed Sira was an agent of respondent vis-a-vis the arrest, detention, and prosecution of the appellant, ground 1. Then B, whether from the totality of the evidence before the court, was the appellant able to prove his case on the balance of probabilities against the respondent. It must also be stated that the respondent incorporated notice of nary objection into their respondent brief, which is to the effect that respondent shall at the hearing of this appeal move the court to strike out this appeal as same is incompetent, in the alternative to strike down the issues for determination. The notice of nary objection is brought pursuant to Order 7 Rule 2.3 of the Court of Appeal Rule 2016. The grounds upon which the objection is brought are that grounds 1 and 2, together with their particulars in the notice and grounds of appeal, are prolix, argumentative, and are purely narrative of the trial court. Ground 2 of the notice and grounds of appeal is vague and general in terms and does not disclose any reasonable ground of appeal against the judgment. The appeal is incompetent and liable to be struck out. I will deal first with the said objection as to its merit or demerit. So I set out the argument of Dr. Ayodele Gata and the argument of the appellant, Onumon. So, and I said, what Order 7 said, I quoted Order 7. It does mean that a ground of appeal must encapsulate the complaint of error committed by the lower court. The grounds of appeal or the grounds must not be verbose, incongruous, argumentative, or a narrative. It must be arranged under distinct heads and must be apt. It must not be an exhibition of mumbo jumbo or rigmarole. Otherwise, the offensive ground or ground will be struck out. Grounds of appeal must be precise and concise and clearly understandable to the court and the respondent to the appeal. Any ground of appeal that is not in tandem with the rules of this court will be struck out. See Okonkwo against Esiaku, 2020, 5 NWLR, part 1718, 477 at 490, by my Lord Galum JSC, and Osahon Nathaniel Obayuwana against Chief John Osamide Adun, 2020, 13 NWLR, part 1741, 371 at 386 to 387, by my Lord Augie JSC. I have earlier on in the judgment set out the two grounds of appeal without their particulars. I've examined the said grounds of appeal and their particulars on pages 426 to 436 of the record of appeal, and I am of the firm view that the grounds of the said notice of appeal can stand alone without the clumsy and unnecessarily wordy particulars relating to each of the grounds of appeal contained in the notice of appeal. The complaints of the appellant are clearly discernible from the grounds, even their particulars. The ground of appeal, which clearly conveys the grounds of the appellant, will not be struck out merely because the particulars relating to it are ambiguous or fake. The two grounds of appeal are hereby adjudged as competent. The notice of ordinary objection of the respondent is hereby dismissed with no order as to cost. Now to the merit of the appeal. I laid out all the arguments of the parties. And I start. The relief claimed against the respondents were anchored on report made to the police by one Inua Mohammed Sira against one Daniel Adeisa, who said Inua reported to the police in Abuja for illegally occupying a shop belonging to the first respondent. The said Inua was reported to be one of the directors of the second respondent. The person reported to the police claimed that he was legitimately put in possession of the said shop in the course of investigation. There is nothing on record to show that the said Inua Mohammed Sira reported the appellant acting as agent of the first and second respondents. There is also no evidence to show that the said Inua Mohammed reported appellant to the police. He reported Daniel Adeisa, not appellant. There can be no agency relationship. The facts of the having regard to the facts of the matter herein, the fact that he, Mohammed Sira, was advised to report the matter to the police will not make the respondents the persons that made false or malicious report to the police against the appellant. And contrary to the reliefs of the appellant, the said Inua Mohammed Sira did not report the appellant to the police. Rather, it was Daniel Adeisa who mentioned the name of the appellant as the person through whom he got into possession of the shop, culminating in the invitation of the appellant by the police. It is the person who reports a matter to the police that will be made liable for the report to the police if it turns out to be false and malicious or without any reasonable or probable cause, and not third parties who has no role to play in the report. See the case of Clement Okafo against Abumo Fuani, 2016, 12 NWLR, part 1525, 117 and 140. Pasanusi JSC who said, now in the instant case, the appellant pleaded in paragraph 491 of his statement of defense that respondent broke into his house in 1997, and he reported the matter to the police. However, the respondent gave evidence on the report made by the appellant to the police against him in 3 sections of the police, whereupon he was invited by the police, arrested, and detained on each of the occasions before being admitted to bail. His case was posted on police notice board for the public to see. The police did not, however, prosecute him after their investigation. It is strike law that where a report is made against a person specifically mentioned as a suspect or accused person, and the report is later found to be false, malicious, ill-motivated, and unfounded, the person so reported, arrested, and detained is entitled to damages to be paid to him by the person who made the false report, since he is the person who set the law in motion against the victim falsely, unquote. My Lord Peter Odili, GSC, on page 149 of the report says, it is a correct representation of the law that if a report, as in this case, is made to the police, which has been found to be totally false, malicious, and without foundation, it is the maker of the report that is liable in damages to the plaintiff for false imprisonment. This is because it is the maker of the report which complainant ignited the action of detention carried out by the police that does not bring in the police as party to the action in the false report and false imprisonment. I place reliance on Iwanobi and Botu, unquote. The failure to make the said Inua Mohammed Sira, who made the report to the police, not against the appellant, but against Daniel Adeisa, a party to this case, is fatal to the appellant's case. It is also pertinent to say that the failure to join the police that initiated the criminal proceedings against the appellant, which proceedings terminated in his favor, is also fatal to the case of appellant from the facts and circumstances of the case herein. I agree with the respondent's counsel that merely reporting a crime or commission of crime to the police ought not to attract punishment unless it is found that the appellant was acting mala fide. Once a matter is reported to the police, bring torchlight. Just torchlight. Just. I hope you can see me. Daniel Counsel. Daniel Counsel, you can hear me? Yes. Can you hear me?
I can hear my
Yes,
lord.
my lord.
All right, we go on. Once a matter is reported to the police, the complainant has no control on how the police will carry out its investigation or prosecution. Since Chief Dr. Fagemi Rokun against Commercial Bank Credit Lioness, 2009, 5 NWLR, Part 1135, 588. My Lord Aloma Miriam Mukhtar, GSC, later CGN, said, as citizen of Nigeria, it is very clear that they have right to report to the police intervention. As citizens of Nigeria, they have the choice to exercise their legal right in placing their grievance before the police, being custodian of law and order. That is where their input stop. Whatever action the police takes thereafter is not solely their responsibility, and they are not solely liable. In this vein, the relief sought by the applicant against the respondent should not be against them alone, if at all there was, or that they instigated the action. If at all there was any arrest and detention, it was done by the respondent, but the police who had the authority to do so. At most, the police should have been joined. And so in this case, police was not joined. And my Lord Ogebe GSC in that case also said, generally, it is the duty of the citizen of this country to report cases of commission of crime to the police for their investigation. And what happens after such a report is entirely the responsibility of the police. The citizen cannot be held culpable for doing their civic duty unless it is shown that it is done mala fide. Then there is a new decision by Supreme Court, and that is the case of Ogwebe against First Bank of Nigeria PLC 2020, 4 SCM 119-134, where my Lord Abaji, JSC said, to instigate is to intentionally aid or facilitate by any act or illegal omission the doing of that thing. The police are empowered to investigate any criminal allegation. They may take any action they deem fit to take upon investigation. They may arrest, detain, and prosecute an alleged offender. See Section 20 of Criminal Procedure Act and 35(1)(c) of 1999 Constitution. In the legitimate discharge of their duties, they cannot be sued in court. The law is well settled. A citizen's civic responsibility include reporting crime and perceived or suspected criminal act, either to his person or to the person of a fellow citizen. And such citizen, after making such complaint to the appropriate security agencies, cannot be held culpable for performing his civic responsibility, unless at the conclusion of the investigation of the complaint he made, it is found that they were baseless and made mala fide. See Fajem against Credit Union Bank. It is not the law that a person becomes culpable and liable to pay damages for making a report to the police. The discretion to prosecute or charge a person accused of crime to any court of law is solely that of the police. The lower court on pages 27 to 28 held that Sarah was not an agent of the first and second respondents, and that what the police did was purely the police action and at their discretion. Again, the appellant did not find it necessary to appeal the above fatal findings, which are no doubt fatal to his case, where a party against whom a finding or decision is made fails to appeal against the decision of finding. Such a party must be taken to be satisfied and contented with such damnifying finding, and decision remains binding on the parties who are affected. CPDM against INEC 2020, 17 NWLR, part 1753, 303, and 335, by a co-GSU said, quote, the law is settled. A finding of fact not appealed is taken as accepted and considered. It remains binding as between the parties. My Lord referred to the case relied upon by Ogi GSC that the effect of appealing only some points in the decision and not appealing other points is that the other points not appealed against remained unchallenged. The same position was taken in Akinlade against INEC 2020, 17 NWLR part 1754, 439 at 461H. The lower court rightly found that the appellant did not prove his case. Issue 1 is resolved against the appellant. On issue 2, as to whether the learned trial judge was guided by relevant principles of law as laid down by the superior courts, I've read the submissions made by the appellant as counsel at the lower court and in this court, and the judgment of the lower court. And I have no doubt in my mind that the submissions made on issue 2 are unfounded. The learned trial judge quite appreciated the guiding principles and the law relating to various issues canvassed at the lower court before arriving at the decision dismissing the appellant suit. 2 examples will suffice, and I refer to pages 417 to 418, where his lordship said that in the suit bordering on malicious prosecution, the onus is on plaintiff to prove, A, that he is prosecuted by the defendant. In this regard, it must be shown clearly that the defendant set in motion against the plaintiff the law leading to criminal charge. B, that as a result of the prosecution aforementioned, the plaintiff was tried by the court of competent jurisdiction, discharged and acquitted. In short, that the prosecution was determined in plaintiff's favor. C, that the prosecution of the defendant was completely without reasonable end or probable cause. D, that the prosecution was as a result of malice by the defendant against the plaintiff. C, CCB, Nigeria Limited against Odogwu, 1990. 3 NWLR Part 140, 646. My Lord also referred to Jim Jaja and COP and continue. Was the prosecution by the defendant? It seemed the answer to this question is not straight one from the evidence of the plaintiff and his witnesses. One Inua Mohammed Sira made a complaint against him and one Daniel Adese to the police. He asserted that he said Inua Mohammed Sira is the agent of first defendant. He said Inua Sira was not joined as a party to this suit. The onus is on the plaintiff not only to prove that Inua Mohammed Sira is an agent of the defendant, but that in laying the complaint leading to the arrest and prosecution of defendant, it authorized him actively to do so. And on page 421, the learned trial judge said, it must be noted that the malicious prosecution alleged by the plaintiff in this case arose from a trial of the plaintiff in CR 95, 2014 and CR 96, 2014. And the piece of evidence produced above emanated from case number CR 96, 14, in which plaintiff was the second accused person. The law is very clear that a plaintiff or party will win or lose his case based on the strength of his case and not on the weakness of the defense. CINE against additional citations supplied. In malicious prosecution, the related cases, such as the case in hand, the plaintiff will succeed if he can prove all the 4 elements as enumerated above in CCB, Nigeria Limited and Odogwu Supra, and in Balogun against Amubi Ikong. Begore GSC said, all the 4 elements above must be present for successful action for malicious prosecution, and the onus is always on the plaintiff to prove each and every one of them. It followed that where a plaintiff fails to prove any of the elements enumerated, he will fail. Unquote. The learned trial judge adequately evaluated the oral and documentary evidence proffered and tendered before he took the decision that the plaintiff, now appellant, failed to prove his case as required by case law. The lower court cannot be faulted. In the result, issue 2 is also resolved against the appellant. The appellant's appeal lacks merit and it is hereby dismissed. Judgment of the High Court of Federal Capital Territory, Abuja, delivered on 14th May 2019, is hereby affirmed. Appellant shall pay costs of 30,000 naira to the respondent. That is the judgment of the court in this matter.
As the court pleases.
Learned counsel.
As the court pleases.
Very good. Thank you very much for your cooperation. We continue to do our best in the discharge of justice.
Most grateful, my Lord.
Thank you very much. So in the absence of any other thing, the court will rise. So if you didn't say it,
Why are you guys?
no, you can't.
I can do that now that we finished, my Lord. Thank you very much, my Lord.
You have already
No, it's not for me.
You didn't let him confuse.
Then what you do, go and prepare yourself. That's all. By the time he sees you appeal like that, that's all. You don't have to tell him.